I think we can begin. So first of all, we thank Dr. Margaret Ng for agreeing to be on standby in case our speaker didn't come. But our speaker has come by, so Dr. Ng is now reprieved. Thank you very much. It's a great pleasure to introduce the speaker for this third session. Actually, I haven't been to the previous two lectures, but you have, so you know all about the speaker. There's not very much more for me to say about him, apart from the fact that I've noticed from the handout that he's given that he'll be referring to some cases in which I was a judge at first instance. And I think there's one reference, there's a dictum of mine that is referred to. But fortunately, that's all that's referred to, at least as far as I'm concerned. And he refers largely to the Court of Final Appeal versions of the judgments of the cases that I handled. But we look forward to hearing what Mr. Clayton has to say about the right to property. Mr. Clayton.
Thank you very much. It certainly sounds like it. Can I first apologize? I'm afraid I'm in the middle of drafting somewhat complicated judicial review proceedings, which have to be done by tomorrow morning. So one of the advantages of being in Hong Kong is I have an extra 7 hours. I'm not sure whether most or any of you have been at the previous times I've spoken, but I'm obviously coming to the end of the series, having spoken on freedom of expression on Monday and equality rights on Tuesday. And I'm grateful for those who have attended and welcome anyone who's here for the first time. In my first lecture, I said I proposed to take my lead from the approach taken by the Final Court of Appeal in the Hassan case, which reaffirms the generous approach that the Hong Kong courts have always taken to human rights decisions from other jurisdictions. If I could repeat a theme which I believe to be important, I think there is very considerable value when doing human rights work of looking at the case law of different jurisdictions, because it seems to me that so many human rights questions are universal in nature, and it's often illuminating to draw upon the collective wisdom emerging from different constitutional approaches to the same issue. Of course, when applying comparative legal principles, one must always be astute to recognize the importance of different legal, political, and cultural traditions. In preparing this paper, I have become conscious that the Hong Kong courts have not really had to address a vast number of cases concerning property rights. If I may say so, it seems to me that the law in this area is still developing, and there are many questions that have yet to be determined, or as I think a jobbing barrister might say, there's a lot to play for, really. There's some interesting things which may yet happen. The one striking feature of the exercise I undertook when looking at this particular topic was whether and to what extent the Hong Kong courts ought to take into account the case law of the Strasbourg court contained in Article 1, Protocol 1 of the first protocol. It's actually quite interesting in a way that the right to property didn't make it into the first draft of the European Convention on Human Rights, that elections and education were so controversial they were deferred. The United Kingdom, who, as you may have seen from recent events, has always been resolute in taking its own position on international issues, hence the Brexit business. They took an equally resolute position about property rights and everything else. It's a very good discussion of all of that, and a really excellent book written by Brian Simpson. I think it's called something like Human Rights and Empire. It's obviously important when one's looking at property rights to recognize and give effect to the different language of Article 1, Protocol 1, when compared to the guarantees contained in Articles 6 and 105. But it does seem to me, and this is the view of the Hong Kong courts, that the broad principles that need to be applied to Article 1 apply equally here. So what are the broad principles? Well, you'll know much more about this than I will, but it's worth pointing out that both Article 105 and Article 6 contain within it an obligation to be in accordance with law, and as you know, the Hong Kong courts have broadly applied the same Strasbourg approach that Strasbourg uses in terms of the prescribed by law and accordance by law requirement, although it does seem to me that some of the cases here are rather more generous than they need be, and they're not really current in terms of the law in Strasbourg has moved on in this field, which is quite interesting. The Hassan case laid down some general principles that land and natural resources in the Hong Kong administrative area are state property, and that when the government leases or grants land, Article 6 plays a complementary role, and emphasised that Article 105 makes no provision for compensation for interference with land short of expropriation, and confines the right of compensation in deprivation cases, which does not diminish the protection conferred against other forms of interference in relation to the acquisition, use, disposal of, and inheritance of property. It's worth saying, I'm not going to say anything about that last phrase, but the Hong Kong law in that area has yet to emerge into its full glory, I think. It hasn't really said very much. Now, I'm going to do this by looking firstly at property and then really land, and then I'll move to land issues. Property is to be construed widely. It's not confined to instances where there's a deprivation accompanied by a corresponding acquisition by the state. It's defined, as you will know, in Section 3 of the Interpretation and General Clauses Ordinance, and you can see for yourself its definition. And although it's worth pointing out that in the Kowloon poultry case, the Court of Appeal assumed without deciding that the profit, business, or goodwill can amount to property for the purposes of Article 105. There is a distinction, as you probably also know, between a deprivation of property on the one hand and the control or restriction in the public interest and how the property should be used. That distinction is a matter of degree. It's worth pointing out that one of the many differences between Article 1 of the first protocol, I'm going to call it A1P1 because it's a bit tedious to keep on saying the same thing. A1P1 actually does cover control of property as well, and it also covers interferences with property. So it's a broader guarantee than the one you have in Article 105. And the question of degree was really addressed by Mr. Justice Hartman in a case called Fine Tower Associates, who felt it valuable, as indeed it must be, to refer to Mr. Justice Holmes, a very distinguished pragmatist, as you probably also know, that there is an implied limitation, said Mr. Justice Holmes, and really, at the end of the day, it depends on the particular facts, which, of course, always makes cases slightly difficult because facts will vary and how you look at facts can vary. Although it does seem to me, I'm not sure that everyone would agree, that when you're looking at a debate which turns on the application of a legal test to facts, that may be a mixed question of fact and law, and may give rise to appeal grounds if people want. Methods of effecting a deprivation of land. Well, this for me was a very steep learning curve because the land tenure in this Hong Kong is not the same as the United Kingdom. So you have re-entry and resumption by the government, deprivation of land using zoning imposed by the Town Planning Board, and adverse possession. I'll say a little bit about that. Now, one thing that struck me when I was looking at the government re-entering land, where it was said, indeed, in no less a distinguished book, which I must say it truly is, Johannes's book on constitutional law, there's an assumption that where the government is re-entering under a lease, it's acting in a private capacity, and therefore it may be out with the scope of Article 105. Well, I wonder whether that's right in every situation, and I want to talk a little bit about an English Court of Appeal case called Weaver, which suggests a more nuanced approach might be necessary. I'll explain a bit both the statutory and factual background of the case. In Weaver, a tenant sought judicial review of a landlord's decision to evict her, claiming it had acted in breach of a legitimate expectation generated by guidance issued by the Housing Corporation, which is a statutory body in the United Kingdom, and as a result infringed her right of respect for private life under Article 8 of the European Convention. It's important to appreciate that the Human Rights Act, which is our stab at bringing convention rights in the United Kingdom into English law, it does it in two ways. There's a strong rule of interpretation, which is a very strong rule of interpretation, actually, which I'm not going to say anything about, but it's interesting nonetheless. And then there's an obligation on public authorities to not act incompatibly with convention rights. There are essentially three types of public authorities under the Human Rights Act. There's what I'm going to call the core authorities, which is essentially governmental, which has to comply with human rights in relation to all of those activities. There's the courts, which is quite an interesting and slightly odd thing the Human Rights Act did, but that's why all the development of the law of confidentiality becoming, in effect, a debate between freedom of expression on the one hand and the right of respect for private life on the other. It's through the medium of the court being a public authority that approach was essentially developed. But there's also a group of authorities called hybrid authorities. And the relevance of a hybrid authority is a hybrid authority has to comply with, must act compatibly with convention rights, save in relation to, quote, its private functions, unquote. So that's why this case, Weaver, is of some interest in terms of what we mean. It certainly suggests, at the very least, that it's not a simple issue and it's not to be assumed. To establish the case, the tenant needed to show that in the exercise of its eviction powers, a landlord was basically a hybrid authority, and that the act of terminating her tenancy was not a private act. That's what she had to say and prove. The landlord enjoyed a substantial public subsidy, and its allocation and management of housing stock was subject to statutory regulation. It was common ground that the landlord, though not a core public authority, was a hybrid authority in the sense that it had various statutory, it could utilize various statutory powers like parenting orders or antisocial behavior orders, which are exactly what they sound like. And those are obviously functions of a public nature. So the English Court of Appeal had to consider whether the act of terminating a tenancy in the context of a body which had some statutory powers, in the way that I've already described, whether that was private. And in determining that question, they just took the view that you had to consider whether the act was in pursuance of, or at least connected with, the performance of functions of a public nature. And they decided that a number of factors cumulatively established a sufficient public flavor to make the provision of social housing by a landlord a public function. And it arrived at that conclusion by noting that the social landlord receives significant capital payments from public funds, so it's social housing we're talking about. It worked in harmony with local government and helped to fulfill the latter's statutory obligation, and it was itself subject to regulations designed to further the objectives of housing the poor. So the long and the short of it is that to say in unqualified terms that there is no circumstance in which, at least in the UK, the government is acting only privately is at least there's a Weaver as a case to think about. Whether it adds much to you in Hong Kong, I can't say, but it just struck me as quite an interesting point. The next point I was just going to say something about was that the act of re-entry appears to be in breach of Article 105, forgive me, in the absence of adequate compensation because the power is disproportionate to the breach. That is consistent with a Grand Chamber decision in Strasbourg called Pye and the United Kingdom. Just to remind you, there are two types of courts in Strasbourg, really. There's a chamber of 7, I think it's 7, The rules have changed a bit. And they have a plenary group, which is when 17 judges sit together. The Grand Chamber is Strasbourg's top court. It doesn't meet very often, about 2 or 3 times a year. I think the total number of decisions it's made is probably, it was introduced when Strasbourg reconfigured itself in 1998. There's probably maybe 200 cases maximum. But they're cases which are really quite important and grapple with issues of principle. And PI and the United Kingdom, as you may remember, decided in relation to the control of use, a reasonable relationship of proportionality must exist between means used and the aim. Although, as I understand it, one would normally apply to a court of first instance to have relief, which is rather typical to the system in the United Kingdom. Although, of course, as you may know, one of the glories of the United Kingdom is the emphasis we seem to place on private property ownership. So tenure is not as important an issue in the UK as here, although for people, like many people in this room, it actually is, because, of course, houses are now so expensive, especially in metropolitan areas, that people have to rent. And rents are phenomenally expensive because all rent controls have been removed, in effect. So it's not a very happy situation, especially for people who are either poor or young or both. Anyways, I've digressed. So I'll say a little bit about resumption, which is a concept new to me, but obviously makes sense. It's like our compulsory purchase process, and it applies because in Hong Kong, a landowner merely holds a leasehold estate from the government. As you will know, I'm sure, Article 105 confers a right of compensation and an open market value, and the basic principles were established by Lord Nichols in a case called Director of Buildings and Land against Shan Feng Ironworks, and approved by the Court of Final Appeal in the Yin Shin Enterprises case. And whilst I remember, I'm absolutely confident during the whole course of these lectures that I have mangled Chinese all the way through, and I do apologize about that. In any event, the fair balance test of pi, I've already said what that supposedly makes difference, and I refer to a couple of cases which deal with how the principles should be applied in respect of compensation. I noted in the course of displaying great diligence because I had a particular reason. I was looking at recent Court of Final Appeal cases, and it looked to me that there's been a recent new case on compensation. I say that partly because Michael Barnes, a person who I've done a case against many years ago, and I remember quite vividly for reasons I won't say well. Anyway, he did that, and he's a bit of a boffin on compulsory purchase and matters relating thereto. And then I draw your attention to the fact that compulsory purchase orders in the United Kingdom are equally subject to property rights. They must be in accordance with law and proportionate. There has been a bit of a debate, and I'm going to come back to this, about the extent to which the necessity test, enumerated by Lord Steyn in the Daly case, actually applies in the Article 1, Protocol 1 field. And of course, that was very relevant for the last case I'm going to talk about, the decision of the Court of the Final Appeal. It's also worth saying that once a compelling public interest has been established, which is what the laws in the United Kingdom, it may not be necessary to consider the rights of each individual landowner individually, but certainly our book takes the view that it's probably necessary to consider the individual circumstances of every owner, particularly before an order is made. I just throw that out there, innocent of whether that has any particular ramifications for here or not. The eviction of owners following the resumption of land, the constitutionality of that, as you may know, was challenged in a case called Wong without any conspicuous success. Essentially, the claimants or applicants, occupiers failed because one of their cases, which looks like a pretty tough one to make, is that everything was on hold until compensation was finalized. That strikes me as a difficult submission. And there was also the government, they said, had to require alternative accommodation. The next question I'm going to touch on is a deprivation of land by planning controls. And here you do get into, I think, complicated issues of fact and degree. There's a case called Fine Tower Associates, where outline zoning plan designated 44% of land as open space and 56% as other specified uses. And that was, I think, said to be enough to be a deprivation, but it'll obviously be probably fairly unusual for that to come into the scope of the constitutional guarantee. I'm going to move now to personal property. And one of the things which is slightly odd, actually in some ways mirrored in a way by A1P1, is, of course, we don't really define in English common law what we mean by property at all. So in the National Provincial Bank in Ainsworth, Lord Wilberforce, a very distinguished judge, hazarded one definition. He said, before a right or interest can be admitted into the category of property or of a right affecting property, it must be definable, identifiable by third parties, capable in its nature of assumption by third parties, and have some degree of permanence and stability. And although property is generally assignable, it isn't always so. Unsurprisingly, as it seems to me, the relatively sparse case law in Hong Kong about personal property has encouraged people to look at international jurisprudence, particularly A1P1, although it's often appropriate, as the Court of Appeal said, to appreciate that there are certain differences in the wording. And that is really very important, because there are very important differences in the wording. You'll see, for example, I've reproduced on page 9 of your notes, paragraph 31, A1P1, and you'll see for a start, it refers to possessions. And the next thing which has to be emphasized is that, because it's always important to remember that the European Convention on Human Rights is a supranational legal system. So, I mean, this was a debate recently which was resolved. I hadn't realized it had been resolved when I spoke on Monday in the Constitution, one of the freedom of expression cases I talked about, which is whether domestic law can define the scope of rights. If you remember the case where it was suggested in relation to one of these demonstration cases that property rights will trump a constitutional function. That has been categorically rejected very recently by Permanent Judge Ribeiro. But the same approach is taken in Strasbourg for different reasons, not because it's a breach of the basic law, but because the only way you can make an international system work is if key concepts are autonomous. And therefore, it's left for the International Court itself to determine its meaning. And I would have thought the reasons for that are pretty self-evident, but we can talk a bit about that if you want to. The difficulty, of course, that arises is Strasbourg is pretty poor at actually grasping definitions in a way which we Anglo-Saxon discursive common law thinkers see things. And of course, the Hong Kong approach is certainly much closer to the English one. In fact, I think judgments here are longer than most English cases. But that is a problem. It's actually, so we have a phrase which is used as possessions, so that obviously isn't property, so it's different from Article 105, that's the first thing to say. It includes immovable and movable property, corporeal and incorporeal interests such as shares, intellectual property such as patent, copyrights, applications for the registration of trademarks. It includes contractual rights like leases, options to renew a lease, covenants to lease, property which is subject to retention of title clauses, which I remember was flavor of the month when I first started in practice some years ago, and judgment debts. Rather remarkably, you might think, a legitimate expectation is a possession under Article 1, Protocol 1, because it's a present property, and it can be a legitimate expectation. Legitimate expectation will be a possession, even if the expectation is unlawful, which is a really odd concept. But that's discussed in 2 English cases, which I footnoted in the paper. So, in other words, if a public body, if you have been the receipt of a legitimate expectation of a substantive character, and it transpires that the person who made it didn't have any statutory authority to do so, or it's outside the scope of the authority that they had, it's nevertheless a possession. Of course, I should have thought the fact it was unlawful would be an important factor in the proportionality evaluation, but it isn't a knockout blow, if I can put it that way. It's also worth noting that welfare benefits can be possessions for the purpose of A1P1, and both contributory and non-contributory state benefits are. I've discussed this at some length, but I really can't say whether it's of any interest to you at all, so I'll leave that for you to think about and decide for yourselves. A1P1 also protects rights under state pension schemes. And, of course, it's worth remembering that unlike the Convention on Human Rights, which, of course, was drafted in 1951, and on any basis is a rather elderly rights system, you in Hong Kong have a constitutional right to social welfare, which I appreciate, like all social and economic rights, raises complicated and difficult questions, but the Convention doesn't contain anything like that at all. Well, in accordance with law, I don't think there's anything particularly interesting about principles applied in the property field about that. Rather oddly, as I read this through, I found that my discussion about whether licenses were property appears in this next section, which is, I don't think is so I am proposing to rewrite these, and perhaps someone will look at them again. But it's quite interesting that there is a strong argument that licenses are property for the purposes of Article 105. There's a case called Manney Transport, where Andrew Young, it was then a Mr. Justice Young, if I've pronounced that wrongly, as I'm sure I have, there was an administrative cancellation of a license to operate a commercial bus service, and he proceeded on the basis that the bus itself was property rather than the license of goodwill, and in doing that he applied a decision of the Court of Appeal on land, holding in the absence of a taking, the use of property had to be so substantial that the owner is deprived of any meaningful use of the property. So I think some might say that that approach is open to question because one's really looking at, with a license, at the license rather than the subject matter of the license, if I put it like that. A different conclusion would have been reached under A1P1. Under the Human Rights Act and under Strasbourg, licenses or permissions to trade are in some, but not all circumstances, possessions. They're clearly marketable and therefore protected. It has been held that personal licenses which have no market value are less clear-cut. It's been held that an existing haulage operator's license is a possession, and it's even been assumed that the permission to act as a doorman fall within the scope of possessions for the purposes of Strasbourg. The prospect of a license being renewed without any being renewed when it's been awarded, I think I mean rejected, and there was no relevant change of circumstances, also arguably in possession. Needless to say, when I did the case, it all went badly wrong. I think principally because it's a very odd case, actually. But it was decided by a deputy High Court judge who was, in fact, chairman of the Competition Authority, a man called Sir Christopher Bellamy, rather distinguished for a deputy High Court judge. I mean, I'm a deputy High Court judge, so you can see where I'm getting in. Anyways, he obviously didn't much like the idea of taxi licenses being subject to some sort of as property rights, because he, I think, took the view that it was a scandal that where you have regulated and limited number of taxi licenses granted, that had an economic value, which he took the view was entirely the result of a state monopoly. So I was representing a group of taxi
driving association who, if you've ever done that, you will know they're assiduous litigators. They're very enthusiastic, except when it becomes expensive, and then they suddenly think, well, actually, why bother? But what happened in Royden was whether the premium value of a Hackney carriage license adversely affected, because what happened in the UK was they lifted the ability, or basically they didn't quite do that. They created a presumption which meant that basically there would be no controls placed on the number of licenses. And taxi drivers who were, worked in the Wirral, which is near Liverpool, but it's a problem of wider coverage than that, all were pretty unhappy because obviously with more competition, they were going to get less money. So it may be better for the consumer, but not so good for the taxi driver and their dependents. Anyways, he decided, Sir Christopher, that it wasn't a possession. It was one of those remarkable cases where we failed to get permission to appeal. Every time something happened, something wrong turned up, and I vividly remember applying for permission from Sir Stephen Sedley. He was then the Lord Justice of Appeal. And he just took a point which came way out of left field, and we just looked amazed. I was leading someone called Stephen Gross, who's a very distinguished human rights lawyer from the United Kingdom, as well as a very nice guy and a personal friend. Anyways, so what we say in Clayton and Tomlinson is that the conclusion of Sir Christopher's is open to question, is persistently open to question, because although he looked all around the world, he did an awful lot of his own research to say why he thought he was right. The Strasbourg cases he applied were those decided by the Commission and not by the court. So they're really of little precedential value, especially since, just to remind you, until 1998, the filtering system at Strasbourg was that the European Commission on Human Rights had to decide whether something was crossed the threshold to go to a final court. The Commission contained some extremely impressive individuals. Sir Nicholas Bratzer, who was the president of the Strasbourg court, and who's a really interesting and marvelous person, really, was on the commission from 1992 to 1998, when he became the British judge on the court. But, in general terms, it's slightly odd that you would apply a commission rather than more modern court cases. Anyways, there we are. That's what that is. The court has held, the Strasbourg court has held that a liquor license may be a possession, even though it confers no rights in national law, because it was essential to the successful conduct of a restaurant owned by the applicant, and its withdrawal had adverse effects on goodwill and its value of the business. A license won't be protected if the license holder does not have a reasonable and legitimate expectation of its lasting character. So a provisional license, which is withdrawn because you failed to comply with conditions or with the law when trying to get it, that doesn't confer property for present purposes. The question of whether a deprivation must involve an acquisition from the state or whether the transfer of a third party is within the scope of Article 105, that is obviously a really quite important question, and I think the state of play on that question appears to be slightly unsatisfactory. It appears to be the case that Justice of Appeal Hartman, sitting at first instance, took the view that restricting a deprivation to state acquisitions flowed from the paramount Chinese version of the Article 105, but apparently didn't take account of some obiter remarks in the Court of Appeal. The Hong Kong courts have decided that Article 105 has no application to taxation, whereas the European Court of Human Rights does. That's actually quite interesting in a way, because on the face of it, the A1P1 appears to say taxation is outside the scope of A1P1, but that's not the case. Then the acquisition, use, and disposal of land, which is the sort of third limb, I suppose, of Article 105, it does appear to me that that is open to quite a lot of development in appropriate cases. In a case called Azadeza as I disarm, so you can see I can murder language. It's not confined just to Chinese. Some of you might think I speak English badly, I don't know. The appellant was convicted of the offence of keeping, they weren't live chickens, they were actually live ones. So you forgive the, as you'd expect, on premises overnight. And he successfully argued that a restriction had to satisfy the proportionality test. So that's kind of moderately interesting. I'm now going to turn to some specific cases. And I have to say, when I read these cases, with the exception of the High San, the things to note is there are not very many of them, and the arguments that were advanced in them were not terribly compelling ones. So the first case is about, it's actually quite an interesting issue. It's about criminal damage. It's a case called Wong Tsui Chin. And essentially, the prosecution appealed against the High Court quashing of a conviction. The High Court found that the defendant was the owner of property concerned, or at least acting as the agent of an owner of property, which consisted of sheds annexed to land and trees growing on that land. The question which arose was really, it's section 60, subsection 1 defines criminal damage. It has to be read together with section 59.2, and section 59.2a refers to the need to have custody or control. And the certified question was, is custody and control limited to lawful custody or control or not? That was the question. And the defendants submitted that reading in the word lawful was necessary for the protection of property. The Court of Final Appeal was not of the same view. The offence was slightly odd and occurred in this way. In 2008, one defendant was sleeping in a shed, awoken by the noise of an excavator, workmen demolishing some tenement structures and cutting down some fruit trees. He ran to the village grocery store to call the police. His father arrived at the scene, having been told what was going on. He remonstrated, which is, of course, a word we always like to use when it was a bit more earthy, the language, but who wasn't present and claimed to be acting on behalf of the registered owner. 2 iron sheds, a pigsty, and the fruit trees were destroyed in what was termed clearance. So the respondent, together with the leader of the demolition crew, was charged with criminal damage in relation to the shed, the pigsty, and the trees. And the question then arose was, it was clearly property belonging to another, but the question was, did you have to read in this extra word, lawful? And it's actually a very interesting and analytical judgment by Permanent Judge Ribeiro. He makes a number of general points, really, including which is he observes that an item of property can be regarded as simultaneously belonging to more than one person. So, for example, A, the owner of a book, lends it to B, who hands it to C. A owns the book, B has possession of it, and C has custody and control of it. So you have multiple ownership. Should D damage the book in C's hands with the necessary intent and so forth, D commits an offence of property which may be regarded as simultaneously belonging to A, B, and C. That all makes sense. He referred to this first approach as the unqualified approach. He did not regard the wording of Section 59 as in any way being qualified, so it's irrelevant that the offender may enjoy superior proprietary rights under the law of property. The second approach he called is the qualified approach. Its adherents argued that in applying the criminal damage provision, you had to look at the relative positions of the parties in civil law. Thus, if a party has custody or control of property, even unlawfully, an interest protected by the criminal law against a mere stranger would be one thing, but it would be different if the defendant was the property's owner. So what it comes to, and it's probably all a little bit complicated, especially at this hour in the evening, what it comes to really is this, is should the civil law concepts be introduced into the criminal law? What's interesting about it is the actual conclusion the Court of Final Appeal came to, because they decided that to adopt a view which was contrary to a report on the Law Commission, contrary to some academic criticisms of a case
of the Court of Appeal in England called Turner No. 2. But he held that the unqualified, in other words, the non-civil law approach, should be applied as a matter of language. He didn't agree that the unqualified approach resulted in a collision, which is a somewhat vivid metaphor, between the civil and criminal law, and he thought that to subject the words custody or control to civil law refinements is unnecessary and produced undesirable results. So he decided that to take the unqualified approach. And he then disposed of the so-called constitutional argument rather tersely. It's a very impressive judgment, if I may say so, and just takes the view there was no question of any infringement of Articles 105 or Article 6. The unqualified approach to the extended meaning does not deprive the owner of any property rights. The owner commits no offence unless without lawful excuse he damages or destroys his property in which someone else also has a proprietary interest, and he took the view the articles simply weren't engaged. So it's a very interesting case on statutory analysis and some quite profound issues about criminal law, but it doesn't tell us very much of interest about constitutional rights. The same conclusion, and an equally complicated case, was reached in a case about money laundering in an interrush, which was essentially arose because police officers in the Criminal Crime Bureau were investigating the applicant for promoting an alleged pyramid scheme. The question which arose, I've set out the relevant provisions, but it's really about section 25(2)(a), this is paragraph 65. If a person who's made a disclosure does any act, he does not commit an offence if before that, under the section, if the disclosure was made before he did the act and he had the consent of the authorised officer. Therefore, sections 25(2)(a) creates a defence based on consent. The applicant argued that there was an interference with or infringement of the Articles 6 and or 105 because it imposed criminal liability without prescribing any time limit for the authorization, any time limit for the expiry of the no consent industry, any compensation by the applicant for the loss of property was withheld through a no consent process. The case was immensely complicated, and I won't dwell on it partly because I think I need to provide you with a hot towel to wrap around your head if we won't spend too much time looking at it. But it's quite an interesting case because he basically decides that the right to property is not engaged at all. He also looks, which is unusual, I think, but I may be wrong on this, in a decision of the Court of Appeal in Guernsey concerning the proceeds of crime law in Guernsey, where the central argument in that case was that permitting the police to freeze funds for certain purposes and it had a consent regime, and the Jersey court took the view that the consent regime was designed to give the opportunity to the police to give an exemption from criminal liability by consent, but on the basis it was in the interest of law enforcement to do so. It was not that, therefore, it wasn't a denial of the right to property, and it was preventing judicial oversight, and for that reason as well, President Lee decided that the no consent regime didn't operate to freeze suspicious property, therefore had nothing to do with Article 8. The next case I think I can take quite quickly. Yet again, this was the case where I think the way one could put it is that the submissions may be advanced with more optimism than the circumstances justified. This was a case about, it was only an application for leave for judicial review about the director of lands creating certain easements and property rights on certain parcels of land, and the question that was advanced was that these easements and permanent rights were not easements in nature, but deprivations of the applicant's use of land. The argument was examined carefully by President Lee, and he rejected the argument essentially saying it was outside the scope of the relevant section, and he does that at sections, as I refer to that debate really, at paragraph 77 and 78 of this rather lengthy paper, for which I apologize. The last topic I'm going to talk about, but actually, as it seems to me, by far and away the most interesting one, is the Dyson development case. And again, you're probably all very familiar with it, but just to remind you, it was essentially about the role of Articles 6 and 5 on private property rights in connection with planning restrictions. The case got to the Court of Appeal, and they decided that essentially the Town and Planning Board should reconsider its decision in accordance with its judgment, and that then went to the Court of Final Appeal. The point of interest in the Court of Final Appeal's judgment are really to do with the proportionality test. And the first question that arose, that it dealt with when dealing with proportionality, is should proportionality replicate the Canadian approach to proportionality, which begins in a case called Oakes in 1986, a decision of Justice Dixon, where there's a four-limbed approach, and the fourth limb is essentially a fair balance test. And just to explain, so you have, as you'll know, the standard ones you'll be very familiar with in the proportionality analysis, and then there's an extra one, which is that if, as a matter of fair balance, it really is oppressive on the applicant, then that might be disproportionate. And there are instances where that succeeded. I was quite keen on this particular fourth limb. I did a House of Lords case called Wong, where we persuaded Lord Bingham to throw that into the pot. And it's worth saying the only reason there was a three-limbed case, this is a really nerdy point, but the kind of things which I find might make law vaguely interesting, is the only reason there's a three-limbed test was because Lord Clyde, in a Privy Council case called Deprivation, applied the proportionality test, the Canadian proportionality test, via cases from Zimbabwe, which obviously is a great credit to the Zimbabwe courts, but it actually wasn't the same as the Canadian ones, and that's when with the submission that succeeded in Wong was, well, look, if we're applying the Canadian test, then why don't we actually apply the test that is in Canada? But, I mean, of course, another element to all of that is that the Canadian courts take a very rigorous approach on proportionality. It's not as deferential as some people favor, and you may get a hint of where I'm going more generally from that. Okay, so that was the first big thing that the case decides. The second is, what is the appropriate test? And it's worth saying, of course, that the point, or a point, about a proportionality test is that it's a structured analysis rather than sticking your finger up in the air and saying, is it rational or not? That's not really, it's a bit intellectually light, really. And of course, it's always, pretty nearly always been. I mean, I've always said, because I lecture on this often, that, you know, if especially to local authorities, if you ask yourself the question, has a public body lost its mind? Well, oddly enough, the answer is no, it hasn't. So it's not a very compelling test. Anyways, the issue that Ribeiro had to look at was whether to apply essentially the necessity test, no more than reasonably necessary on the one hand, or whether the question was manifestly without a reasonable foundation. What's odd about it, I mean, he reviews the cases, and it's interesting to see the way he deals with it. He looks at the Privy Council case, which rejected the Canadian approach to proportionality, Lee Kwong Kut. He then looks at a different test applied in a case called Ming Pao newspapers. And then he looks at a case called Bank Mellet, which reaffirmed the four limbs of which reaffirmed really the proportionality test as understood in the United Kingdom. The first thing to note is it says, although this is not done in practice very much, it depends on an exacting analysis of the factual case by reference to the four limbs.
What's interesting about the Bank Mellet case is it's an A1P1 case. It's in a national security context that may be important, and it was about a rather draconian sanctions visited on a bank which was said to have been trading illegally with Iran, I think, from memory. So he looked at that. He looked a little bit at the Canadian material. He looked at the Strasbourg material, which is slightly equivocal. But there's a series of Strasbourg A1P1 cases which use essentially the without reasonable foundation case. A case called James, which James was about the expropriation of the Duke of Westminster's long leases, which he was very against, unsurprisingly. He's a very rich man. The result of the expropriation scheme was that he came out of it rather badly. And then a number of other cases, including some town planning cases. So said Ribeiro, that the government and the court reiterates that, this is from, this is from a case called Focus, which is a relatively recent Strasbourg case. The court reiterates that the contracting states enjoy a wide margin of appreciation in their town planning policy. Pausing there, can I just make a point about the margin of appreciation? Because for reasons, it does appear to figure in some of the jurisprudence in Hong Kong, and I do wonder whether that's correct as a matter of analysis. The margin of appreciation, whatever it is, and there's a long debate about what it is and how it works, but that is the deference that a supranational court accords to a domestic court, or what European Union lawyers would call subsidiarity. Basically, the primary role of domestic courts is to have domestic courts. In 1999, David Panic, who you may have come across in Hong Kong because he seems to have a second home here, he came up with basically doing the same thing. It's an interesting article he wrote called Discretionary Areas of Judgment. And it does seem to, as a matter of nomenclature, that is a better way of looking at deference than referring to the margin of appreciation. Because the margin of appreciation imports a whole load of other things. And as I think Lord Steyn used to like to say, taxonomy in law is always quite important. And he was certainly a great judge, and he was right on that. Justice Ribeiro then looked at a number of UK cases. Carson, which I talked at great length about, the wonderful judgment of Lord Nichols in Carson, which shows saying very little can tell you rather a lot. It's still an incredibly powerful judgment. A case called SG, actually, which I spoke about also on the equality rights thing, which was a housing benefits case, and shows you that even without reasonable foundation, manifestly reasonable foundation, claimants can win in particular circumstances. And some Hong Kong cases, Lau Chong, Fok Chung Wei, and Kong Yamin. He said that the difference between these two standards is one of degree. There was a spectrum, and the manifest standards have been used in cases where the originator of the impugned measure is better placed to assess the appropriate means to advance the legitimate aim espoused, and is given a wide range of appreciation. So he summarizes it all, but having regard to the time and your ability to read, I'll let you look at the summary at your leisure, or not at all if you've decided it's all got too tedious for words. And I'll come straight to my conclusion, really, which is this. It does seem to me that on any view, the judgment of Justice Ribeiro in the Haisan is a magisterial survey of the various approaches the courts have had around the world in identifying key elements of the proportionality doctrine. And it implicitly articulates a methodology for developing a theory of judicial deference. It was a subject I used to champion, the need to have one. For some reason, that was why we intervened in Hong Kong, and Huang, and lost big time, because Bingham thought that judicial deference was easier to apply in practice than to define in theory. A good example, I think, of ducking a problem by it seems to be having a theory of judicial deference is actually quite important, because it helps judges work out what they're supposed to do. Anyways, leaving that all to one side, although it's all the things that I've suggested it seems to me it leaves a number of questions or a number of issues of principle about proportionality uncertain. First of all, are the different standards of proportionality that he identifies in an A1P1 case reasonable necessity on the one hand, manifestly without foundation on the other? Is that standard convincing when the United Kingdom Supreme Court in Bank Mellet reached a very different conclusion, the reasonable necessity test, under A1P1, so same article, but importantly, different context, and that's national security. So is that decisive? Don't know, but it is striking, and it's not discussed in the judgment. The second issue it raises is how and in what ways does the manifestly without foundation principle differ from the conventional rationality principle in the administrative case law, in administrative law case law. So this question, at least, what is the point, or where have we got to with constitutional rights if you're going back to what we in England would describe as a Wednesbury test? It's just a slightly strange place to end up. It is particularly a strange place to end up if, as it appears to be the case, I just expressed one reservation about appears to be the case, because you may have noticed we've had a changing of the guard in the Supreme Court. We not only now have a female president, we actually have a second woman who's on the court. So that's obviously a change, and it's unclear what people will do. But there has been a series of Supreme Court decisions grappling with this question. Should administrative law decisions be subject to a structured proportionality test rather than a simple rationality test? And there have been three or four sort of discussions about it, including a case I did, which was another forensic disaster called Kennedy, which was a very interesting case about freedom of information and also about whether Article 10, whether freedom of expression extends to a right to information. It was a case lost in the Supreme Court. We were not entirely surprised. We succeeded to getting the Grand Chamber to say they had got that wrong. So sometimes one has to take the victories where you find them. But anyways, there's a lot of discussion by Jonathan Mance and about what Wednesbury versus, or rationality versus proportionality in general, and a debate amongst them. It's even odder because it was never even argued before them. So why they launched off into this? They're obviously writing lectures, and they were debating these issues amongst themselves, which is understandable because it's interesting and important. Where we've got to in the Supreme Court, subject to whether one would have said until the recent retirements that proportionality was going to replace a rationality test. Interestingly, in the most recent attempt at it, in a case called KU, Lord Neuberger thought that this couldn't be an issue decided by a 5-judge court. It had to go to more judges because it had such important constitutional ramifications for the United Kingdom. Because as you know, we certainly don't have a written constitution, although we do have constitutional principles. But the long and the short, and I made a bit of a meal of all of that, is this, is it's very curious when the United Kingdom is moving away from a rationality test for Hong Kong to have adopted it. The next question I want to raise is this. As a matter of practice, this is a kind of broad but practical point. How will a town planning officer actually apply a manifestly without foundation test? I mean, imagine you're the person on the ground. What on earth are you supposed to make of that? Quite difficult, I think. It's not the kind of words I imagine that you talk about at home with your partner. How's your day been? Manifestly without reasonable foundation. No, well, it's just one of those days. The next question, which is a big one, I think, and I may have sort of said this already, is in requiring this generous standard, which is so deferential, are the courts really according appropriate respect to constitutional rights? That's a question you could argue to the end of time, but it is a question. And the last point I raise about the analysis of Mr. Justice Ribeiro is, does it extend beyond planning questions? Well, it must do, I suppose. But to what, and when, and how? So it leaves a lot of things uncertain. So that's why I said I think there are principles, big principles at stake. So to reach my conclusion, which probably is not very profound, it is obvious to me, at any rate, that Articles 6 and 105 are still a developing area for work. I believe it, and hope it, you accept that it's instructive to look at the approach taken in decisions in the United Kingdom about the Human Rights Act in Strasbourg, since they may provide some pointers for future directions. My sense is that there's much to emerge in this field in the future. I hope I've succeeded in sketching out some indicia about the sort of directions the new case law might take. And may I conclude this, and I hope there's time for questions if you're not too exhausted, just by saying two things. First, I'd like to personally thank Johannes Chang for all the assistance he's provided to me in organizing this event, which I've hugely enjoyed. Personally, I hope it's worked for others. The second thing is to say that I feel immensely privileged in giving these lectures in Hong Kong by being given really quite a considered opportunity to see how important constitutional rights are addressed here. It seems to me, and to many others, that judicial dialogue between courts concerned with international rights jurisprudence cuts two ways. And these lectures have helped me enormously to see how the case law developed in the Hong Kong courts might inform courts elsewhere into answering some universal human rights questions. And of course, I have my own vested interest, I think, to some extent, is if we ever rewrite a new edition of the world's longest book, which is 1.1 million words devoted to comparative and everything else about human rights, then certainly I know a lot more about Hong Kong than I did before making this series. So thank you very much.
I think we have time for one or two questions. So are there any questions? Johannes.
For this very comprehensive survey. Now, the traditional proportionality test may involve two parts, the rationality and proportionality. Now, conceptually, they can be distinguished. Practically, it seems they have been terribly mixed with one another, and occasionally it appears that courts are more willing if you attack the matter on the basis of rationality, simply because it seems deceivably involve less value judgment, whereas if it's a proportionality involving a range of choice, courts are more reluctant to do it. Now, I wonder whether you detect the same trend of this separate treatment of rationality and proportionality, because if we look at the Social Security case, for example, when the court used manifestly without reasonable foundation, the way they use it in the differential charges for obstetric services, the Fortune-Wah case, it is very much a deference. But when it comes to the Social Security case, I would say that the analysis of scrutiny is as stringent as any proportionality test, but it seems that there is a slight difference there. The court seems to have a tendency to lean more towards the proportionality, the rationality limb than the proportionality limb. I wonder whether you see the same kind.
Thank you. We'll take one more question, and then we'll let Mr. Clayton answer. Any other question? If there's no other question, then I will add mine to what Johannes has asked, and that is simply to say, what is a judge to do? When I was a judge handling the Lee Hai-san case, there was a lot of technical information about wind values in Causeway Bay, about certain laybys, why you have 5 meters instead of 4 meters or 3 meters. So how is one supposed to apply a proportionality test to that? I found it much easier to apply a rationality test. So I would echo what Johannes would say. The academics, Johannes Chan, others, can argue all they want about proportionality, rationality, 2 limbs, 4 limbs, but a practical judge simply says, does it make sense? Is there a rational explanation for this? And for that 5-meter layby, there was no rational explanation in Lee Hai-san. So a practical judge says, well, on the 5 meters, the government loses. On everything else, the government wins. Isn't that what the judge is supposed to do? Apply a robust approach. Mr. Clayton.
Well, that's two very interesting questions, if I may say so. I'm afraid I have differ rather substantially. I'm afraid that I'm very much persuaded by people like Paul Craig, who's a colleague of mine on the Venice Commission and who I admire hugely, about the idea of a structured test. I strongly believe that a structured test at least can assist a judge in applying principles, and then you see where you get to. The danger of a rationality test, to move to the what to do problem, is that I think an analysis is better than a hunch. And actually a rationality test is really a hunch. How's it feel? Now, I accept that there will be many cases which are essentially about ultimately how you feel, but one of the arguments I would put forward for a proportionality test is one of legal methodology and analysis. It's not good enough for people just to know the result. It's quite important to know the path by which it's approached. And so, although I certainly concede that there are huge areas of debate about this, for me, at least one thing which is always slightly frustrating for a client is they say, well, I just don't understand why I lost. And to be told by someone it wasn't rational, well, actually, that's an epithet. It's not really a very analytical phrase. So I entirely understand why practical people can sort of see it, but I think the ultimate justification for a structured proportionality test is the methodological one of saying that if judges have to explain how they get to outcomes, then I think it's a better outcome for the rule of law. So that's my answer.
Thank you very much. I think that concludes this evening. I'd like to thank everyone for staying on, and I'd like to thank the speaker for the trilogy, which comes to conclusion this evening. Thank you very much.
I'm sorry I didn't have a chance to speak to you for longer.